Hi everyone, this is Yashwant Grover, Managing Associate Intel Advocate, and I'll be talking about IP and licensing issues in brand collaborations in the fashion industry. The entanglement between fashion and intellectual property is deep and ever expanding. From brands such as Gucci to logos such as the Nike swoosh, to designs such as the Crocs shoes and patterns such as the Sabyasachi design, all are protected by some form of IP. Even fashion patterns are on the rise, such as your wrinkle-free fabrics, water-repelling textiles, and textiles that are resistant to fire. The fashion industry is reaching new heights. In the current times, fashion is certainly more than just clothing and textile. Intellectual property has a big role to play in the development of the fashion industry. Did you know that the Indian Army recently got registration for the latest camouflage pattern and design for improved combat uniforms? As the fashion industry is rapidly evolving in recent times, there arises a dire need to obtain protection of the products in terms of the creativity and other such processes invested therein. In the fashion industry, IP licensing is the process by which the owner, that is the licensor, of a particular patent, brand, trademark, graphic, or any other IP, which is referred to as the property, grants another party, that is the licensee, typically a manufacturer, the rights to use the IP in exchange of payment of royalties. This can be done by way of brand extension, brand collaboration, or through any such agreed upon route. Sometimes fashion brand companies may even be granted license to use copyrighted images, like you see the Disney characters on various products. IP licensing is subject to an IP licensing agreement, which is drawn between two parties, that is the licensor and the licensee, and the terms therein which lay down the right and obligations of both parties for the duration of the validity of the agreement. Because the use of licensing within the fashion industry is common, and understanding of the legal aspects of licensing and the role it plays in the expanding brands is important. While IP licensing offers an exciting opportunity to both big and small entities to reach a wider range of consumers, it has its own pitfalls if undertaken without proper due diligence. Cross-brands collaborations are the latest trends in the market nowadays. They can be seen everywhere, from fashion to beauty to travel to sports and tech. Collaboration between companies in diverse sectors are becoming more common, resulting in new innovative products. What motivates businesses to work together is the chance to give something exclusive to their respective fan base, whether it is in form of a limited edition product, a collectible item, or even a special promotion. Brand collaborations are also referred to as collaborative branding or co-branding, can create exciting commercial opportunities for businesses. Brand collaborations are one way of making people excited for upcoming fashion releases and often result in whimsical and outlandish items where two brand identities meet to create a one-of-a-kind aesthetic which can often become mainstream in the world of fashion. Co-branding allows the partner companies to share the cost of the collaboration while also expanding into each other's consumers market. The latest example of a collaborative model which is up on the rise is the Nike Tiffany shoe that merges the iconic Nike swoosh and the famous Tiffany and Co blue color. Products like the Nike Tiffany shoes created through co-branding use the strengths of both parties to gain consumer interest and creates excitement in the new consumer base. And those who love Nike will also go for the Tiffany shoe, right? Because it's a different chain altogether. It's collaboration between the fashion and the jewelry brought together into a new fashion market. Despite all the benefits that can come from a collaborative partnership, businesses should take effort to protect their current respective IP rights. Equally important, the party should consider the ownership rights of the new products created under the collaboration. This is where an IPR collaboration agreement or a license agreement comes into play. A collaboration or a license agreement between the parties outlines the relationship of the two parties and involves cross-licensing of IP rights for commercial activities. In any collaboration agreement, the parties will cross-license the IP they contribute, but the parties should state clearly the scope of license and how IP will be used in the collaborative partnership, and what is the termination clause, till when is the IP valid, what are the jurisdictions till when they can expand their IP. Both parties should also lay out all their IP assets created prior to the collaboration so that each party is respectively aware of what everyone brings to the table. Fashion collaborations result in creation of new intellectual property, where new products, services, or other materials are created. It is important for brands the ownership and management of such valuable IP is protected. You may think IPR ownership will be straightforward, but that's not the case, as it depends on the type of collaboration and the specific terms which are agreed upon between the parties. From the very start, establishing clear legal terms and clauses will ensure both the parties benefit the desired outcome and will also help in managing any potential IP disputes. Though these collaborations can be highly effective from a commercial standpoint, there also involves significant potential risk for businesses. For example, if your collaborator sustains negative publicity during the course of collaboration, your business could itself sustain these damages through your association with that collaborator. If you need an exit from the collaboration after jointly branding goods have been created, you may not be able to sell those goods. And third, if you opt not to proceed with the collaboration or cancel a collaboration which is already underway, you may be at risk of breaching contractual commitments to your collaborator, as well as the manufacturer, logistics, even third parties, exposing your business to potential lawsuits. The very famous Adidas Yeezy case is the most recent example which lays down the risk associated with collaboration, and every brand owner should look at it before getting into a brand collaboration. The split between Adidas and Kanye West, who's the owner of the brand Yeezy, in 2022 is probably one of the most financially taxing collaborative split in the recent industry. It further goes to show how negative publicity garnered by one of your collaborators can affect your brand identity, and not only for the co-brand, but even your original products. Prior to the split, Adidas Yeezy line of merchandise was considered as one of the most successful brand collaboration in terms of both popularity as well as the revenue generated. It is estimated that Adidas Yeezy line was generating $1.8 billion in annual sales. That is more than 40% of the company's profit. And that split alone has cost Adidas around $250 million loss in 2022. Even for Kanye West, his earning was $1.5 billion. His net worth has come down to only $400 million. It's not like after the split, Adidas can, just happily sell your Yeezy sneakers. Kanye company holds a portfolio of at least 160 trademark application and registration for the Yeezy brands. Whereas Adidas, on the other hand, own rights to the design of the Yeezy branded shoes. So this means Kanye is licensing his Yeezy name and brand, that is his trademark, to Adidas to put on their footwear and apparel. And because of such licensing agreement between the two, Adidas likely will own Kanye any outstanding royalties for products sold under his brand up to the date of termination of his agreement. Adidas could attempt to sell the shoes without using Yeezy's brand, but the association of the Yeezy brand with Kanye West and his anti-Semitic statement has left a bad taste in people's mouth. This itself brings into question how valuable your collaboration is, right? Now, before getting into any collaboration, one should ensure that proper due diligence has done, proper steps have been taken. Therefore, you need to take into account few possible risks. And in order to do so, one, conduct appropriate due diligence to ensure that any known risk which can be impacted by the values of your collaborator's brand can have on your sorry. Before entering into a blind collaboration with a third party, businesses should take into proactive steps to guard against any possible risk. Number one, conduct appropriate due diligence to ensure that they are apprised of any known risk which may impact the perceived value of the consumers to the collaborator's brand. Second, ensure that they have a collaboration agreement in place, which includes the term, appropriate exit provisions, demarcation of rights, and the quality check, should there need be to end the collaboration. And third, consider how they can manage any other legal or commercial or logistical issues which may arise if that planned collaboration ends sour. And fourth, carefully conduct and consider the scope of IP licenses to be granted to the collaborator and seek advice from your lawyers before entering any such agreement. Even if your business conducts careful due diligence on a collaborator, it may not always be possible to predict how or why a collaborator may sustain negative publicity during the course of a collaboration. However, having an appropriate legal and commercial strategy in place can help your business successfully negate such issues that may arise. To conclude, licensing has potential challenges, but fashion brands can minimize their risk by selecting partners that upgrade their product line. And for licensor evaluating potential partners, they should look for brands that promote the collaborator mindset and situations where both can come out as winners. And most importantly, have an airtight license and collaboration agreement in place, clearly mentioning the ownership of new rights, use of the existing rights, scope of protection, the term, the termination clause, and the geographical area which applies to your license. Thank you.